So in continuation to our discussion about the draft DPDP rules 2025, let's talk about how the data of state beneficiaries are going to be processed. Welcome to my YouTube channel where you daily see new content on data privacy, and these days we are talking about the draft DPDP rules for which today we are going to talk about the data processing for state beneficiaries. We'll first quickly touch base about the new things or the modified things that have come in the draft rules. We have already covered the first item, which is the issuing of notices to data principals. We have spoken a lot about consent manager, which is a new thing in a way that the consent manager is to be external, third-party agency, is capable of providing service either manually or through software tools, and has to be registered with the Data Protection Board of India. We've spoken about the registration process, the statutory compliances, the obligations with the principals and fiduciaries. We are now talking about the state beneficiaries, and subsequently we are going to talk about the reasonable security safeguards, the personal data breach intimation process, and the timelines that the government has decided for those intimations. Finally, we'll talk about a verifiable consent while we are processing children's data. Right? So let's move on with this. We'll talk about the state beneficiaries. Clause B of Section 7. What is this clause? This clause is that there are a set of people who are state beneficiaries who take schemes or who avail schemes launched by government for the welfare of poor people. These could be for any service related to health or housing or even direct rationing food and shelter as well, right? So people who are beneficiaries, they provide their data to the government. They have to provide their personal information to get those benefits, and when they provide that information, government takes open consent from them. Government can utilize this information while processing their personal data without the need to go back for an explicit consent for processing their personal data. For example, one of the ladies gets enrolled under the government maternity benefits, and she gets the benefits. Personal data is provided by her, that gets processed by the government. Government determines eligibility, benefits are provided. Now this data is a part of the government machinery. She has already taken a benefit, she's got enrolled, she's provided one consent. Now for any other thing, no further consent required, government can utilize the data. This helps the state to deliver the services very, very effectively and efficiently. Right? So how would this data be processed? This would be processed as good as all the other processing mechanisms of data privacy. Very, very lawful manner, only for personal data, only for the use cases. Which use cases? Government schemes and beneficiaries. Right? It's not a saleable data, it is not a shareable data, it's to be used only for the government beneficiaries. Make responsible for the effort to maintain accuracy. So the same things, right? You have to make sure that the rights are available, the accuracy is available. You are not expecting those beneficiaries to log in themselves and keep changing their or verifying their data, but you should expect that you yourself as a government agency or as a fiduciary in this case maintain the accuracy of the data. Retain the data till you want to use it, or you can retain it even if it is required to be retained under any other law. And reasonable security safeguards, the encryptions, anonymizations, they are all need to be maintained. You need to provide the contact person, the person collecting, person responsible for processing, communication links, notices issued, information sent. So you're not directly saying notices issued because you are talking of beneficiaries. They may not be capable of understanding all that, but you still need to inform them in any form, online and through letters, that their personal data is being used, and you have to use them only for beneficiary purposes, not for all purposes. You have to follow all the general data privacy practices and ensure that anyone processing data of state beneficiaries is fully accountable for that. So that's about the processing of personal data of state beneficiaries. I hope you like the content of the video. Please press the bell and the like icon. Subscribe to my channel if you have not already done that, and share your feedback in the comment section. Thank you.